And the question is, what about attorney's fees and as you start to escalate this up the ladder? And if, I'm going to tell you, if in fact you went down a path that you had a fine and a notice and an opportunity for a hearing and non-compliance, and then you went and incurred attorney's fees, and then you kind of looked at it and said, you know what, maybe not. Yeah, you'd have to waive those fees too, because those fees are predicated on that initial fine. And it's I hope that they weren't too much, and I hope your attorney caught it quickly, so that they weren't going up that path and just escalating it, because those do. If the owner were to prevail at court, you'd be paying not only your attorney's fees but their attorney's fees.
Yeah, that was the logic we used as we reviewed the case.
Yep.
One came in for the hearing and we're reviewing all of this out.
Mm-hmm.
We said we can support this, we can support this, but this one's a little bit gray.
Yeah.
And we thought that it would be in our best interest to stay out of court.
Yeah, and that's where you should probably just dump those fees too. Okay, so we have said you can charge use fees, and we can go. All right, you also have the power, authority, and I would argue duty to adopt budgets, to let owners know what they're spending their money on. You have to, again, do zero-based budgeting and let the owners know where their money's going. So you do have to. You can't run an association, a corporation, without a budget. You have the power to hire and terminate managing agents without specific authority in your declaration. So your declaration may provide that you have to have a professional manager. Those that are silent, they are allowed to get professional management. You have the authority, the power to institute and defend lawsuits. Getting back to your question there, looking at the overall situation, you can act on behalf of all owners. And typically this comes up if you are the plaintiff in a covenant violation, in a collection suit, in a construction defect suit. If you are defending a lawsuit, it's because you took action to collect assessments, enforce the rights of the association. So you do have the right, power, and duty to institute and defend lawsuits. You have the duty to regulate the use of the common elements. Getting back to some of those questions we had, charging use fees for the common elements, well, you also have the authority to regulate the use of the common elements, such as setting speed limits in parking areas or on drives, contracting for and providing snow removal at specified levels, restriping, closing parts of the common elements off during periods of repair. So you have the power, even though it may not say it in the declaration, to regulate the use of the common elements during periods of ownership. Okay. Regulate. Section 303 goes on to state you have, gets back into the duties of the association, stuff you have to do. Information related to the operation of the association made available to the directors. This is a statute that was adopted a couple years ago, and it essentially states that any information obtained by one director must be made available to all directors. And this was a situation, what brought life to the statute is you had a community that one director was running it like a fiefdom, his own private kingdom, and was not sharing any information with anybody. And in spite of being asked, this particular board member wouldn't give any information to anybody. So, because the owners complained and approached the legislature loud enough, we now have this statute that says anything that's received by one of you must be made available to all of you. And this includes opinion letters, reports, budgets, finances, anything you get from the accountant, any professional of the association.
To all directors or all?
To all directors. We'll get to the rest of that in just a minute. The owners. You have fiduciary responsibilities to the association. Getting back into, you have to act in the best interest of the association when you spend their money. Yes, ma'am.
Can we go back to the information part of it?
You bet.
What if you have a director that made an agreement with a homeowner, he didn't share that agreement he made with the board of directors,
Mm-hmm.
he just did it on his own, and it caused the board of directors to not be able to collect an overdue assessment?
Okay.
Is there any recourse that
Yes.
the board of directors have?
The question is, what if one director is making side agreements with other directors, or not other directors, but owners, and it has damaged the association to the extent that you can't collect assessments, you can't do X, Y, or Z. Now, this gets very tricky, but the answer is yes, the association has the ability to recover that, some of that. To the extent that, one, did the association grant the authority to this particular board member to go out and negotiate this deal? If you guys were at a meeting and you said homeowner X is delinquent, Director Y, why don't you go out to him, see what you can do, negotiate a settlement? Well, then probably not. Although he needs to bring that back to the board and say, I did this, and this is why, and you gave me authority up to X number of dollars to do it, so then it becomes binding on the association. However, if the director, without specific authority from the board of directors, goes out and cuts a deal with a particular homeowner and says, you know what, homeowner, not only am I going to waive late fees, penalties, interest, attorney's fees, I'm going to cut the amount due in half. And you just pay that to me personally, and we'll be good to go. Then, no, the association has recourse, because you can, that was a usurious act, or not a usurious, an ultra-virus act. That just means beyond their authority. And if they act beyond their authority, they become personally responsible for any delinquency or anything that goes beyond. Now, when I say that, obviously, if you go to the director and say, you know, director, you cut the deal, you cost us $1,000, pay it up, director's going to look at you and laugh. It's to enforce some of these things may require a lawsuit, which gets into the intervene, defend, lawsuit mode. But you as a whole, you as a board have to act as a unified body. And one director cannot just go out and do what they want to do without approval and or authorization from the entire group. Each one of you is placed in the fiduciary capacity or the position of trust of the association when you're elected. And you must act in their best interest. And it's not in anybody's best interest if you're out cutting deals on the side and acting on your own. So there is recourse, there is liability. May require a lawsuit to do it, and depending on the size, you have a duty to look at the cost-benefit analysis of a lawsuit. You can say, you know what, it's going to cost us $10,000 to go after that $1,000. It's going to cost us, X number of dollars, X number of headaches. It'll damage the reputation of the association. Oh, and by the way, we'll never get anybody to serve on the board again. You can do that analysis and then act as a reasonably prudent person would do and say, all right, cut our losses or go after it. And that gets to that fiduciary concept. You guys are stuck. A fiduciary is somebody that's in a position of trust. And as such, you have to act that way. And this gets to why you can't, we get questions of board member proxies. Owners can give their proxies to vote at the annual meeting. Can a board member give a proxy to another board member to go vote for them at a board meeting? The answer is no, unless your document specifically says that you can. And even if your documents specifically say that you can, it must be so directed. It must state that I, David, give my proxy to you to vote for the painting contract at this much dollars for this much of a time period. It has to be that specific. It has to be like you were there, because that's ultimately what you're doing, is you are voting for a matter like you were there. So that's the limitations on board proxies, and they have to be specifically authorized by your declaration, or by your bylaws, I'm sorry. Any questions? All right. We continue to move on this wonderful journey of the Colorado Common Interest Ownership Act. We've talked about the standards of care when you invest your reserve funds. You have the power to appoint committees. Committees of the board, they all serve at the pleasure of the board of directors, meaning that if you appoint an architectural review committee, subject to the terms and conditions of your declaration, but if you appoint an architectural review committee and that architectural review committee kind of goes rogue and starts approving, well, normally I'd say red or black houses, but we can go Detroit Red Wing red houses. You can bring them back in. You can rein them back in as a board. They serve the board. and they must act in accordance with that. Yes, sir.
Okay, so a committee, that I assume does not need to be members of the board, they can be homeowners at large?
The only qualification, they can be homeowners at large, and the question was, do committees have to be board members? The answer is no. They can be homeowners at large. The only obligation is that any chair of a committee must meet the same qualifications as any board member must to serve. So if a board member is required to be an owner, the committee chair must be an owner. If a board member is required to be current in their assessments, the committee chair must be current in their assessments. Whatever is in your bylaws regarding qualifications of a director, the same applies to the qualifications of the chair of a committee. Just the chair, not necessarily everybody else.
Okay, so then, do we indemnify them?
The question is, do you indemnify committees? And the answer is, your bylaws and articles provide for it. You would also name them in your directors and officers policy, and your directors and officers policy should state that it's the association's name, the board of directors, any committees, and if you have a manager, name manager. Not if you have a management company, name the management company, but name manager. There's a specific reason for that. Because let's say you've got management company 1, and you renew your policy in January, and management company 1 is your manager January, February, and you change management companies in March. If your insurance policy names management company 1 in the policy, guess who's not covered under your insurance? Management company 2. You want to make sure your policy states and your management company, not a specifically named management company. There's a requirement that you may audit your association books. Audits of association books come about in a couple different ways. 1, if the board of directors elects to have your books audited, or 2, if you have over $250,000 a year of revenue and 20% of the association demands it. Then you have to have your books audited.
Or it's in the declaration.
Or if it's in the declaration. And we get to those next. But that's the statutory framework. There is no statutory requirement that you have your books audited. Okay. So we go to notice requirements. Meetings for notices. You must notice your meetings of homeowners. Now, how many people? Well, let me start with. Do you think you can notice your meetings by email? Annual member meetings.
Yes.
Yeah. Is that the only way you can do it? No. Do you? All right. Let me see. I'm phrasing it. Whoever's down there going, no, you're right. Notice of annual member meetings. A notice of any member meeting must go out by U.S. mail. Now, it can go out by email as supplementary, but not primary. You must still send every notice of an annual meeting or member meeting by the U.S. Post Office, unless you want to hand deliver it to every member in your community. That is another option. You can hand deliver it. Agendas. You must make agendas reasonably available. Now, what is reasonably available to you?
For us,
To you.
if I call you, you can get it to me in some way.
You can deliver it upon request. The statute just says reasonably available. We have interpreted that as if you have it available at the meeting and an owner can come in and pick it up, that's reasonably available. There's no affirmative duty to send an agenda of a meeting to any owner prior to the meeting. You can make it available at the meeting. You can make it available online if you post everything online. These are some of your powers to making it available and your boundaries. Open meetings and discussion rules. Okay. As we've talked about, every meeting of the board must be open to all owners who wish to attend and their designated representatives. So if an owner comes up and says, you know what, I can't attend the meeting, my friend Larry the lawyer is going to attend in my stead, you have to let Larry in. You can't preclude meetings to homeowners. Yes, sir.
Can we ask the homeowners to notify us since we're meeting in, the kitchen tables of most of our board members who we rotate around, and if 20 people wanted to show up, that might change where we hold the meeting?
The question is, can you ask kind of for RSVPs to the board meetings? You can ask. unfortunately, you can't demand. And if I'm just walking by and I see, yeah, that's my board, you got to let me in if I knock. And it's just one of those things that, you know, again, that's the way the statute's being pushed. We're getting away from meeting in owners' homes. That's kind of the way it's becoming a real big inconvenience. I'll come right back to you. Yes.
To send a representative in your place,
Mhm.
don't you have to have a proxy or a written authorization?
You can require that it be in writing, yes. Yes.
I guess the thing with getting away from people's homes, we hardly ever have anybody.
Well,
If they have a problem and they
Right.
want a meeting
Yeah.
because of a violation. But would we have the option, let's just say for some reason, 15 people showed up
yes.
and at my home, because we're having it at my home, and I cancel the meeting and say we're going to have to reschedule, we don't have the space to put people in?
Question is, can you cancel a meeting if more owners show up than is desirable? When I say desirable, then the facilities allow. Better way to put it. Yes, you as a board can get together and say, you know what, this is way more turnout than we thought we'd have. We're going to adjourn this meeting. We'll pick it up in 24 hours at Starbucks, pick it up at 24 hours at Panera, pick it up at 24 hours at Heinemann Sanchez, you name it. Yes, you can. Now, you have to re-give notice, and you have to, again, still let everybody in. And does it become an inconvenience? Of course it becomes an inconvenience. But can you? Yes, you can. And you can say, you know what, if we're now going to have 20 homeowners at a meeting, which is great, we love it, we're going to have to find a place to start meeting. And it may mean that you have to start paying a nominal meeting fee for a library, for a church, for a warehouse, wherever you may end up meeting.
In our yearly meeting, we naturally
Yeah.
have.
Mhm. But this is just board meetings. And that is the tough call because, as you had said, normally you get nobody. And is it really worth it? No, probably not. But if you start to get, I guess, in answer to your question, if you start to get crowds, yeah, plan on finding a new place to meet. Okay. Now, homeowner participation. Who thinks homeowner participation in an open forum is mandatory? No. There is no requirement that you have an open forum. The only requirement is that before the board makes a decision, at a time determined by the board, you must allow each owner to speak. Whether you want to do that in an open forum, that's your conduct of meeting policy. Whether you want to do it just before you vote on a matter, you discuss a painting contract, and you get to the point where you close debate, you open the floor to the owners to express their opinion about the contract, you can do it then. Now, I know many associations like to have both. They like to have an open forum, and they like to allow owners to speak right before an issue because it may be two different topics. And quite frankly, I think it's very good to have an open forum and then have them speak before a particular topic, but there is no requirement in law that you do so. So it's just that you must allow owners to speak before you may take a vote on any particular matter. Yes?
It's general practice, and I've seen that
Mhm.
with 3 HOAs.
Yes.
They always invite for every meeting the homeowners,
Mhm.
and that is their choice to attend or not.
Yes.
But the homeowners can hear everything what is going on,
Mhm.
and if necessary, only if necessary, they can put a comment on it.
It's the general practice, if I understand you right, the general practice is that, yes, homeowners do have the option to attend.
Right,
If they attend, they have the option to sit back and be quiet and just observe.
right.
They have the right to speak before the board takes a vote, not an option.
That's right.
I mean,
But
if they want to speak, you must allow it.
they see the whole process in that tape
Yes. Mhm.
before that final stage comes in,
Yes,
and that is what makes it very valuable.
it does.
What the rationale is behind.
Hmm. And that's why, it's if you require everybody in open forum to say, look, we're going to vote on painting, landscaping, and snow removal, give us your comments up at the very front of the meeting, and then we'll go on, we'll do our debate. Their comments may be lost. And you are absolutely right that if they can see the entire process, some of their questions may be answered and they may choose not to participate. But they have a right to participate in accordance with statute.
Right.
Yes?
Can we place a time limit on how how long they can actively participate.
Yes. Question is, can you place a time limit on how long they actively participate? And the answer is yes, you can. You have a conduct of meeting policy. The conduct of meeting policy says every owner shall be given 1 minute, 2 minutes, 3 minutes. Whatever that policy states is how long they have the ability to address the board. Now, I will also tell you that when you're doing it, use your policy routinely. Every meeting. Don't just pull it out for meetings that you feel are controversial. Or don't just pull it out for meetings when your neighbor's coming and he's long-winded. Use it every meeting. And if you're using it every meeting, it sets expectations. It's working how it should do. And then when an owner's come up and they are infuriated about the $100,000 special assessment you're going to require to levy, you can say, you remember this, guys? Minute each. I don't want to hear any more. So
Is that one of Kiowa's policies?
that is one of the Kiowa policies.
Yeah, I'm not gonna imagine.
Yes, you are. Okay. We've talked about the executive session requirements. You can only go into executive session on specified times. Yes, sir.
Question, if you
Yes.
have a time limit for speakers,
Mhm.
if an owner says, I want to give my time to
Mhm.
this person, you have to give that person twice the time.
The question is, can somebody cede their time to another speaker? And I will tell you the answer to that lies in your policy. Your policy can state nobody can give time to anybody else. Your policy can state we have 20 minutes, period, for owner comment. We really don't care who takes them up. And if owners all want to give their time to one person, they can. That's policy specific. And it really should be addressed in your policy, because that's another way you can do it, is say, we're going to have owner comments for 20 minutes, and anybody that's there, we're going to divvy up the time. So if 4 people are there, you can go 5 minutes each. Now, that is excessive if 4 people are there, because I'm sure you don't want to listen to 4 people talk for 5 minutes each over a painting contract, but you could. It's how your policy reads, and those are some of those powers that the association has, and the boundaries the association has, is it can tailor their policy as to how they do business, and how you do business, and what fits your association, and what fits a 100-owner townhome community may not be the same as fits Highlands Ranch, and may not be the same as fits some other community. So it really is, you guys can tailor those documents to how you guys want to conduct your meetings. As long as the minimum requirements are owners are allowed to speak before the board makes a decision, and they're open to all owners. Okay?
Conceivably, a homeowner could speak throughout the meeting, because there's always a point of discussion. There's just not there are always decisions being made, even if there's not a vote.
No, because the way the statute read, and the question was, so conceivably homeowners could occupy the entire meeting because you're always having discussion and you're always making decisions. It's only on votes. The intent is these are board meetings, they are business meetings, and owners can discuss or address the board prior to the vote. Not prior to, well, we're going to do this, this, and this, and we think we should have a picnic, but no decisions made. No, you can. Now again, this is the ability of the association to get business done. And I don't want to say keep the owners quiet, because owner comment is very important, but it allows you to manage when the owners talk and address the board, because you do still need to get your business done, and this is a business. Okay, executive session. Any more questions on executive session?
I have a question on notice.
Notice, yes.
Did you say anything about it has to go through the mail?
Mm-hmm.
Is there a minimum number of days that notice has to be sent out?
Yes, and there is, Kiowa states that meeting notices for member meetings must be sent no less than 10 nor more than 50 days prior to the meeting. Now, check your bylaws, because your bylaws, some bylaws say owner's notice must go out no less than 30 nor more than 60. That's typically the one we see. Obviously, the 30 is still applicable because it's shorter than the 10, and you must give 30-day notice for an annual meeting, according to your bylaws. Now, you can't give 60 because the maximum time frame the statute allows is 50. So it's a little bit of a floating number to the extent that it's contrary to the Colorado Common Interest Ownership Act. But yes, the Act says 10, no more than 10, no less than 50. No less than 10, no more than 50, yes.
Put in the mail 10 days before the meeting.
not that they receive it 10 days?
It's part of the Nonprofit Act, and I hate to start mixing statutes on you, but part of the Nonprofit Act says fair notice means 3 days mailing. So realistically, you have to give 2 weeks notice for mailing and receipt.
We do it, we just do the mail and we do emails. They
You
get
do-
the email immediately.
They get the email immediately, but the email is supplemental. It's not your primary, so you have to go on what is done by the mail. And I would recommend, highly recommend, unless you know your mail is getting there overnight, 2 weeks. It's just, and again, remembering, this is one of those, let's talk about your risk. If you, let's say you throw it in the mail 10 days, your risk is somebody showing up at the meeting with a post-dated envelope saying, you only gave me 9 days notice. I object to the meeting. Well, technically you have to do it again then. Now, is anybody going to show up at the meeting and say, you only gave me 9 days notice, and oh, by the way, I don't waive my right to notice? You're here. Waive your right to notice, just come into the meeting. So, it's, yes, sir.
What if your meetings are second Wednesday of every month?
Okay.
Posted in a quasi-quarterly newsletter.
All right. Now, getting back to types of meetings. Owners' meetings require no more than 10 nor less than 50. Board meetings are required by whatever's in your bylaws, or if you have a regularly scheduled board meeting, no meeting notice at all is required. If you set at the beginning of any year, second Wednesday of every month is going to be our board meeting, you need no further notice. Second Wednesday of every month. Now, again, let's be fair. You should post it on a website. You should put it in a newsletter. Don't go try and hide behind, well, we told you, because then what's going to happen is owners will start to say, all right, I want specific notice of every meeting 2 weeks or 24 hours before every meeting. You're going to be sending out emails. You're going to be sending out this. The intent is to foster participation, have open meetings, so make sure it's posted somewhere. Yes, ma'am.
If you change the location, and this year we changed the date of the board meeting,
Uh-huh.
we have to do a mailing.
No. Again, getting back to, there's no affirmative duty to notify owners of board meetings unless they ask, but you should always, again, let them know. Post it on your website, post it in the community if you can, foster that participation if you can get it. Okay. Okay. Executive sessions. Conflicts of interest. The Kiowa makes whatever's in the Nonprofit Act applicable to the Colorado Common Interest Ownership Act. So we've discussed it. It's just you have to, if you have a conflict, notify the board and act pursuant to your conflict of interest policy, which I know everybody has because everybody's update with the requirements of SB 100. Here is, I think, what we've been talking about the most recently, is Section 317 of Kiowa. And this gets to the board's duty to make association records available and what those records are. Section 317 was amended at the beginning of this year. And it now defines what are the sole records of the association. And the sole records of the association, it defines what the permanent records are and how they must be made available for inspection. They won't necessarily disclose architectural plans for an addition.
But there's,
Yeah.
you can.
Oh, you can see the plans, yeah.
You can see right away what is going on
So.
there.
Any questions on how 317 has been retweaked?
What's permanent record?
Permanent records of the association is stuff the association must keep forever. As long as you are an operating entity, you must keep meeting minutes. You must keep your declaration, bylaws, articles of incorporation. You must keep the meeting minutes of anything done. You have to keep any resolution you adopted outside of a meeting. You have to keep any emails any email discussions used to lead up to an email decision must now be kept as records of the association permanently. The concept being is if you guys are chatting away on email saying, I like contractor 1, no, I like contractor 2, and then you guys get into and say, okay, let's approve contractor 3 as a compromise, those emails are now association records that must be kept and disclosed. The concept being is that was your discussion. That was the debate that took place at a meeting, and you now have to make those available for inspection.
So, if I understand, there's a new law passed by Governor Hickenlooper.
Yes.
That all the correspondence between the board members should be available to homeowners, and that they have to use a separate website, no more personal email addresses.
And the question is, as he understands the law, do you have to use separate email addresses? Do you have to use no more personal emails? The answer to the question is yes and no. And I say yes because we are highly advising you to get association business specific email accounts, because you would not use your corporate email address to conduct personal business. We're asking the same, or really what's kind of being implied is they want to make sure that you're using, again, this is a business. You should get a business email address to conduct association business. It also makes it much easier when somebody comes up and says, I want to see every email that you guys sent concerning this that led to this decision. You can sit and say, okay. And you print it out. Here it is. Nicely done. As opposed to going into your personal email account and saying, okay, let me find it. And you take some time to find it. And then the owner says, you know what? I don't believe this is it. I'm going to go ahead and sue, and I'm going to subpoena your computer. And I want the court to tell me that this is it. Better to just keep it on a separate email server. Keep your corporate work away from your personal work, just like you wouldn't use your corporate email address for any personal business. Yes, ma'am.
Is a printout of the emails on file than you ultimately want for inspection?
Ultimately, the statute says is it must be easily reduced to a writing. So yes, ultimately I want to be able to walk in within 10 days and say, I would like to see every email regarding the painting contractor, and you'll be able to sit there and say, okay, here they are, and print them. That ultimately, yes, that's what I want. But of course, if this is 5 years ago, you can have them on a disc or something. You know. Yes, ma'am.
And the emails also apply to discussing a homeowner violation or whatever it has to do with.
If it leads to a decision, yes. Okay. All right, we've got about 10 minutes. Next slide, please. All right. Now, everything we have been talking about appears in the Colorado Common Interest Ownership Act or the Colorado Revised Nonprofit Corporation Act. Your bylaws may restrict this further. Your bylaws sets forth specific powers and limitations for the association. They may or may not be mirrored in the declaration. A lot of developers, when they were bringing their communities out of the ground, they went ahead and they put the same restrictions in the declaration in the bylaws. May not be the case, but sometimes it is. If there is a conflict between the provisions of the declaration and the provisions of the bylaws, the declaration controls. So if your declaration says an association may do X, Y, and Z, and typically it comes up with borrowing. If an association has the ability to borrow, it's going to appear in your declaration. The Colorado Common Interest Ownership Act states that any association can borrow as specifically provided for in the declaration. So if you are, this is where it typically comes up, but your declaration may say you can borrow, and then your bylaws say you can only borrow with 50% approval. So we've got to start checking both of these documents, 50% approval of the owners. These are going to be limiting powers, and it is really important to sit there and, again, look at your declaration, look at your bylaws to find out specifically how the Nonprofit Act may be further restricted or how the Colorado Common Interest Act may be further restricted. Budget limits. The Kiowa says that you can, without specific authority, adopt a budget and assess. Your declaration may say you can only increase assessments 3% a year, or you can only increase assessments if you're going to increase it more than 3%, you have to have 67% approval of the owners. That's a limitation of your powers that is set forth in the declaration.
The declaration trumps.
The declaration will trump if it's more restrictive. Yes. Your declaration or your bylaws may contain audit requirements. Your declaration may state that the association shall audit its books every year. Well, Kiowa says you don't have to. Your bylaws or your declaration says you do. Bylaws and decks control. Next slide. Insurance. Kiowa sets forth very specific insurance provisions. It says you shall obtain D&O insurance. It says you shall obtain property insurance. Your bylaws may go further than that. Your bylaws or your declaration may say, not only are you going to obtain insurance, I want you to get a fidelity bond. I want you to do this. I want you to go out and get specific limits of insurance. So you have to go through and again look at what your bylaws and see how your bylaws and your declaration may amend or modify what's in the statute.
Do the bylaws trump the declarations if they aren't restricted?
No. If the declaration and the bylaws are inconsistent, it always defaults to the bylaw or declaration. The enforcement of covenants. Your specific declaration may contain a procedure how to enforce your covenants. Now, we've all said you have to have a policy, and I've been harping all night on you have to have a policy regarding enforcement of covenants. That policy must contain what's set forth in your declaration. And I know there's a group of associations that were put together by the same developer, and they all contain similar language. And it required notice and 5-day notice, and then you had to have a tribunal, and the tribunal had to contain a certain amount of people. And with those people, only one had to come from this particular building and another had to come from another building. And it was an effort to try and say, look, this is a community, and if a violation is going to be found to exist, we want representatives from each one. It was not the board. The board could not act as the tribunal. It had to be other people. So that's going to add to or further restrict the provisions of the Colorado Common Interest Ownership Act, which says you can enforce your covenants and you have to have a policy to do it. We talked about borrowing. Borrowing is a big one in that if you are a pre-Kiowa or your community was created prior to July 1st, 1992, the Nonprofit Act says you are empowered to pledge your property, your income, you name it. It was unrestricted or unfettered borrowing. Kiowa came in and said, you can only borrow to the extent provided in your declaration. So you've got different limitations. Now, of course, your bylaws may contain a different restriction that says, and I just amended some bylaws that said, the association can only borrow if 100% of the owners and 100% of the first mortgagees approve the borrowing. That's never going to happen. But that was what the developer wanted. They did not want the association ever to encumber its assets, so you're stuck with that. So we had to go through and we had to amend that provision out before the association could borrow. So you do have these further restrictions. Lawsuits. Colorado Common Interest Ownership Act says you are fully empowered to intervene or defend or initiate lawsuits. I defy everyone in this room to look at a declaration that was drafted in the last 10 years. By a developer that does not have some sort of massive restriction on how you can initiate a lawsuit. Most specifically, a construction defect lawsuit. There are going to be provisions in there that says you have to have 67% approval of the entire association and the developer to initiate a construction defect lawsuit. Okay, but it's further restrictions on how the association can act. And these are some of those boundaries that are put on associations that are contained in the declaration. They're contained in the bylaws. And I have not mentioned the Articles of Incorporation once tonight, other than at the very, very beginning. There are at times restrictions set forth in the Articles of Incorporation. And I've seen Articles of Incorporation that prohibit an association from charging use fees because they wanted to make sure that all the amenities were open to every owner in the community. Yes, sir.
Can the board change any of those, like the declaration or bylaws or articles of incorporation?
The board can, to some extent, change the bylaws without a vote. And the question was, can the board change these documents? The board can change the bylaws to some extent unless the bylaw is reserved specifically to the owners to amend. The declaration, you can amend, but it's from the owners. It requires 67% approval of all owners pursuant to statute unless a smaller amount is set forth in the declaration, so it's between 51 and 67%. Articles of Incorporation are actually just about the hardest document to amend. Normally they require about 67% approval of all owners in the community, and there's no other way to do that. There is no statute that says, well, we're going to go ahead and help you and we're going to reduce that. So a lot of times the articles are really, really hard to amend, even though it's the most innocuous document that I don't think anybody, well, I take that back. I'm sure you have all read your articles. It's the document that most people just throw in the drawer. It brought your association into existence and nobody cares since. So it's, yeah, you have to actually look at that document too to see, to make sure that you're acting fully in compliance with the governing documents. And it's a tricky one. So yes, you can amend it. Each document has their own specification.
Articles of incorporation trump the declarations.
No, declaration trumps everything. It's your constitution, for lack of a better term. It sets forth the minimum guidelines. Now, any other questions? We'll take a couple questions and then we'll call it. Yes, ma'am.
I have a really dumb one.
I doubt it.
Well, I missed the first 5 or 10 minutes. So I sat through this whole thing not knowing what you're saying when you're saying Kiowa.
Kiowa is the Colorado Common Interest Ownership Act.
Okay,
It is
that's
the,
what I thought it was. I just wanted to make
yes,
sure.
it is the organic statute that governs all common interest communities in the state of Colorado to some extent. What is Kiowa? And Kiowa is the Colorado Common Interest Ownership Act, which governs all associations. Yes, ma'am.
So you named 5 of the policies. Can you name all the Kiowa policies?
Oh, you're killing me. All right.
I'm sorry.
Question is, what are the 9 required policies? Let's see if I can get them out. It is a policy regarding adoption of policies. Don't laugh. Policy regarding covenant enforcement. Policy regarding conflicts of interest. Policy regarding collection of assessments. Policy regarding conduct of meetings. Policy regarding investment of reserves. Policy regarding a reserve study policy. And inspection of records. That's 9. 9?
I got 10.
You got 10. I did one twice.
Was reserved and reserved.
There is a reserve study policy and an investment of reserves policy. 2 unique policies. There's an alternative dispute resolution policy. So that should be your 9th.
I'd have so many. It's unbelievable.
We've got a couple duplicated. Yes.
If our declarations specifically say that owners may rent their units.
Yes.
Now, there are some guidelines they have to follow, such as provide a copy of the lease, so on and so forth. But if there's no restrictions that we can place on the rental of units without a 67% vote to change that, then
You cannot restrict rentals. There is a vested right of the owners to rent their unit unless you amend the declaration. Yep.
So even if it affects FHA and...
Even if it affects FHA. You got to amend the document.
30%.
Yep. You've got to amend the document to restrict rentals in any case. All right. I will call that a night.